Hello, my name is Sarah Young and I'm a contentious probate solicitor with Ridley and Hall in Huddersfield. I deal with a lot of inquiries from people in relation to wills when someone's died, and one of the things that always surprises me is how few people seem to understand that cohabitees have very few legal rights when a loved one dies. If you're living with someone and they haven't made a will, when they die, you have no automatic right to inherit anything from their estate, unfortunately. And the situation with Boris Johnson and Carrie Symonds has very much brought this into focus, because if Boris Johnson hasn't made a will, then had he passed away with the coronavirus, then his children would have stood to inherit, however many children he may have, they would have stood to inherit all of his estate. His fiancée, girlfriend, live-in partner, Carrie, would have not automatically been entitled to inherit a thing. Now, if they'd been living together for more than 2 years before the death, then she would be entitled to bring a claim under something called the Inheritance Act 1975. And obviously he hasn't passed away, and that is good news, whatever one thinks about politics. But it's a really hugely stressful, difficult, horrible, unpleasant thing to have to do, to bring a claim in court to say someone's estate has failed to make reasonable financial provision for you. But it happens so often to people who are cohabiting. If you're not in a civil partnership and you're not married, you do not have the same protection that you would as a cohabitee. So it's really important, if you're living with someone, that you talk about making a will, and ideally you make a will using a solicitor who is properly regulated, who can explain the circumstances to you, what will happen if, and it's the thinking about the what ifs that really matters. You're not over all the hurdles at that point. If you make a will, very often people who are living together make a will where A leaves everything to B and B leaves everything to A. That's called making a mirror will. The two wills mirror each other. That's okay, but if you're in a blended family situation where you both have children from different relationships, for example, it's really important that you know that if you die before your partner, everything you have goes to them, and they don't have to and won't necessarily leave anything to your children on their death. That's not necessarily because they've got bad intentions or they're a bad person. Circumstances can change. Life just brings all sorts of different circumstances for people. The surviving partner might remarry, or they might lose mental capacity, or they might just fall out with your children. So there are issues to be thought about if you're in any kind of blended family and you're thinking about making a will. Do give it some really careful thought and make sure you get proper legal advice about what to do. My name's Sarah Young and we are Ridley and Hall.